Welcome to another edition of Your Long Range Plan. My name is John Kennan. I have with me my friend and colleague Paul Tierney. We are estate planning elder law attorneys with offices in Sandwich and in Quincy. And I want to welcome Paul. Hi, Paul. How are you?
John, how are you today?
Great, great. So what do we have to discuss today? We talked a little bit prior to the show, but I just wanted to make sure that we were more or less on the same page about what happens when somebody passes on with a will or without a will, the impacts of not having a will when you pass away. If you'd like
we can also discuss a little bit about trusts too, if you'd like. That would be that's okay.
All right. Well, you're a friend, colleague, but you're a guest, and I'd like you to just say a few things on some practical experiences that you and I have had with clients that are always, for the most part, asking us, geez, do I need a will? Do I not need a will? I don't have a lot of money. All I have is a house. The house is paid for, but that's all I have. I think you know where I'm going with this.
Right. Well, again, if you pass away, there's two ways that you can get your assets to go to the people that you want. And the best way is to have your own will in place. We'll also talk a little bit about trust later, but a will is a legal document where you get to appoint who's going to be in charge of your estate, who's going to pay off bills, debts, expenses, and then who's going to carry out the rest of the terms of the estate, which is basically to get your assets to where you want them to go, to benefit the people that you want to benefit. Now, if you don't have a will, then unfortunately or fortunately, the state has one for you. It's called the intestacy statute. So depending on your status when you die, that's going to determine, if you didn't have a will, who gets what you have. So right off the bat, I always recommend absolutely make sure that you have a will. There's three no-brainer documents that everybody should have: a will, power of attorney, healthcare proxy. And whether you need a trust or want to have a trust or not, that depends on particular circumstances and factors that we'll touch on a little bit later. But for right now, we're going to talk about having a will versus not having a will. There's a very famous author, who just became famous. His name is Stieg Larsson. He died back in like 4 or 5 years ago. And he had 3 unfinished novels when he died. He really wasn't worth too much when he passed away. He was a writer. He did some political commentary. He wrote some actually science fiction short stories. And he had a long-term live-in companion. And for, I think, income tax purposes, they had decided long ago not to be married. They didn't have any children, but she was with him for like 32 years. And after he passed away, I'm not sure who it was who finished his 3 novels, but one of them became, it's international now, called The Girl with the Dragon Tattoo, which I have read and which I thought was excellent. I also have his other 2 novels that are that kind of take place a little bit later, but have, I believe, a couple of the same characters in the book. So now we have a United States-based movie coming out about this novel. I mean, the novel itself has done terrific. Actually, all 3 of them have. There was a movie produced by Sweden back a few years ago, which I saw on the first novel, which I thought was excellent, and now we have the United States movies coming out. I believe it's out now, or it's about to be out in a couple of weeks. But the point is this person who had a relatively modest estate died as a multimillionaire. Again, after the fact, because his estate is going to benefit from the sales of the novels, from the sales of the rights to produce the movie, etc. And many times after the fact, there's other economic revenues that get generated, and that would all get payable to his estate. But unfortunately for him, he did want to benefit his long-term companion, and he had a will set up that had a lot of his estate going to a charity, but then he wanted all his publishing rights and publishing materials, written materials, to go to his long-term companion, but the will was never validly executed. So therefore, it does not take. And in his situation, because it was not a valid will, just like in the United States here, if you die without a will, then that's where the states that you have died in, the state that you're a resident in, the intestacy statute it will take over and determine, who gets what of your assets in your estate. So unfortunately for Stieg Larsson, he did not substantially benefit his long-term companion, and I believe that's still in litigation, which is too bad.
Because in his case, when you say he did not validly execute a will or have a valid will, it's because although he had an expression of his wishes, clearly the intent was there in written form, didn't sign, didn't have his signature witnessed, therefore the laws of intestacy take over. And in this case, where he wasn't married to this other person, his companion of 30 years kind of takes a back seat to the intestacy laws that you've outlined or you've mentioned, and those go squarely to relatives.
Right, and in his situation, because they weren't married, then she did not have any rights under the intestacy law of the county, state, country where he died. So very, very unfortunate, again, assuming that he wanted to benefit her, which I believe that he did. But the will wasn't valid because it wasn't signed. And in Massachusetts, it has to be signed. It has to be witnessed by two people. We and most attorneys like to, in addition to that, have the will notarized. So if the will's notarized with the witnesses, then that just makes it easier to get the will allowed when somebody passes away.
So let me ask you this. You've talked about having a will, a valid will, and not having a will. Is there any instance where there's a gray area where some things are disposed of through a validly executed will and others are just kind of hanging out there because of newly acquired information that these assets were acquired? And is there ever an instance where something can be held in this gray area that needs to be addressed?
Well, maybe gray area being the fact that how were the assets held? So if they're held jointly with somebody, then it doesn't matter what the will says, doesn't matter what the trust says if there is one, doesn't matter what the intestacy laws are where the person passed away. That's going to go to the joint account holder. The same would be true with several assets are passed by a beneficiary designation, or we do have brokerage accounts that can be set up like a for the benefit of designation. So if it's set up like that, then what that means is on the demise of the original account holder, it's going to go really by contract to the person designated as the beneficiary. Life insurance contracts, IRAs, those pass via beneficiary designation. So it's important as part and parcel of your estate plan to make sure that those are coordinated. And any estate planning attorney, that would be one of the first things that they want to know about is what are your assets, how are they held, and depending on the type of estate plan that you're going to put together, you want to make sure that those assets are coordinated with your estate plan. Because again, you can have the best will in the world, you could have the most fantastic trust drawn up, but will they be effective? And that depends on how your assets are held at death.
Okay, so because this is an educational program and we're always trying to educate, and as you've said so many times in the past, Paul, not trying to sell anything except to impart some information, hence the educational component. We understand clearly that having a validly executed will is key for disposition of one's assets. You and I have been on the receiving end many times of individuals saying, oh, I jotted down some of my wishes on a yellow pad of paper. That's how I want things to go. So even though that person signs before two witnesses and has it notarized, are there any legislative, are there any powers? What are the ingredients? I know the answer, but for the public, are there any certain ingredients or definitive terms that should be embodied in that written expression of one's interests?
Well, you need to declare that it is in fact your last will and testament. But you need to be careful too, because there's a lot of things that should be in the will that if you're going to handwrite it yourself, you're probably going to miss. So sometimes handwritten wills, if they are validly signed and executed, can be allowed in Massachusetts. But I would advise against it. I always advise go see a professional. It depends on what's going on. You want to make sure that there's enough power clauses in there so that you can do what you need to do, or your executor can do what needs to be done efficiently and effectively when your time comes. Otherwise, there's other hoops and hurdles that you have to go through, and time delays. If there's time delays, that means there's more expense involved. So again, there's a right way of doing things, there's a wrong way of doing things.
Opens up a great door in terms of my question, your answer regarding certain powers, in the pros and cons of having a validly executed will and not. Specifically, when one has a validly executed will and it embodies the power to sell, you and I both insert that power all the time, the power to sell a house, real estate, etc.
Yep.
That works well, because if there is a piece of real estate or a home that needs to be sold for a particular reason, because that power is embodied in the will, the fiduciary has the ability, or the executor has the ability, to sell that piece of property, sign a deed as executor, etc., etc. Without the validly executed will, without that power, it goes to something that you were touching on, and that's all those extra, very expensive situations where without a will, you have to go to the court, you have to file documents asking that someone be appointed an administrator of the estate, and in the case where there's real estate, what happens? Go ahead.
Well, you'll need a license to sell the property, which means it's an extra petition, extra time and effort before the probate court, and it's kind of a pain in the neck, in my opinion.
Inexpensive, additional expenses.
So again, yeah, it's avoided if you have a valid will in place. I mean, not only that, there's other circumstances too where, again, you need the appropriate power clauses in the will. You could have a closely held business involved. If you don't have language that deals with a closely held business, then what's going to happen if your executor needs to sell it? Again, same situation. You're going to have to go to the probate court and ask for permission. So a separate petition, separate hearing before the judge. Those can sometimes be contentious, especially if there's family members involved. So a lot of times if we're selling real estate and we have the assents of all the heirs, then yeah, it's additional work and time and effort, but it's relatively straightforward. If you're selling a business and there's family members involved and you don't have all the assents of the family members, then that could be problematic and you're just asking for trouble. So again, I think that's all avoided. If you do have a valid will with the appropriate power clauses, that's where you need a professional to kind of understand what are the assets involved, what are the power clauses that we should have involved in the will, so that if we do come across that circumstance where the executor, or what our new term is going to be personal representative, if the personal representative has to be involved in the liquidation or sale of a closely held business, you want them to have the power built into the document to do so, as opposed to having a separate court procedure to just ask permission to do something you should normally be able to do.
Yeah, in the long run, having the will fully executed
with the appropriate power clauses.
with the appropriate powers avoids an awful lot of unnecessary trips to the court.
Correct.
Asking the court, in essence, for one's permission to do whatever it may be because the powers are lacking.
Right.
You mentioned trusts a little while ago at the opening of the program. If we could talk a little bit about a couple of different types of trusts, one being a living or a revocable trust, and then maybe later on an irrevocable trust or an asset protection trust, that would be great. First, could you talk about, since we're on the topic of wills, could you talk about how a will, a validly executed will, works in concert with a revocable or living trust?
Well, it depends on what the trust says. It depends on what the will says. Usually as part of an estate plan, if a trust is involved, we usually try to tie the two together. We usually have what we call a pour-over provision in the will that basically says, hey, the rest and residue of my estate, have that go into the trust if it is not in there already. Because if we do have that type of an estate plan in place, then we want to fund the trust during lifetime. Now, to fund the trust, that means getting assets into the trust during your lifetime. So it could be as straightforward as taking that trust document down to the bank and talking to the customer service person at the bank and saying, hey, I need to retitle my savings account or my CD or my checking account into the trust. Most of the time they want to have a copy of the trust. They may just require a copy of the title page and the signature page. Every institution is a little bit different, but that's how you would fund your trust with a bank account or a certificate of deposit or a savings account at a bank. You have to go to the customer service representative and they would fill out paperwork and have you sign that so that when you did get your bank statement, it would say the name of your trust on it.
So your savings account, your checking account, whatever the account is, would have the name of the trust on it.
Correct. Again, that's if you're going to the extent, if that's part of your estate plan, then that's usually a recommendation. Then the same thing with life insurance proceeds or possibly qualified plan assets like IRAs. But this is where you need to get some tax advice first because that may or may not be appropriate to name the trust as the beneficiary. But usually with life insurance, if there's a revocable living trust involved, we like to have the trust named as the beneficiary.
So let's back up for continuity. We talked about wills. Let's say we have a valid will. The valid will, if I'm following you, might say, I leave all of my tangible personal property, which would be chairs, paintings, fishing rods, jewelry, etc., to my spouse or to whomever else. And then everything else, whether it's personal property, which would be cash, stocks, tables, paintings, and or real estate, with a house on it or not, and wherever situated, to my trust. Hence the pour-over terminology. Why do we, and again, I know the answer to the question, but I have to ask, why do we prefer that pour-over will and trust rather than just a will situation? Depending on the assets, the wishes, beneficial interest from that point of view, if you could answer.
Well, again, I think it depends on the reason why you have a trust in the first place.
Right.
And again, that really depends. There are lots of different answers to that question. Could be like myself. I have young children, and I have my estate plan set up so that if myself and my wife passed away, we want to benefit our kids. But I don't want my kids to come into whatever's left over when they're age 18 because I feel that's way too young and they can be easily influenced and they don't have enough experience and maturity to handle whatever would be left over. So I have directions. I have put together my own set of rules, so to speak, by putting together my own trust and my wife's trust. And in there we basically want to benefit the kids, but in such a way that we'd be able to have them all educated before they could do what they wanted with what was left over. And again, we set up our own rules stipulating that they have to attain certain ages before they would take.
I was going to ask, yeah.
So I think it's important. That's one of the reasons for a reason for having a trust is if you have young children involved, or even young adults, or if you have disabled children or adults, all the more reason for having a trust. Because again, you can set up your own rules, your own stipulations as to who would get what when, and just as important, who would be in charge of managing those assets during the time frames that you select. So that's a big reason, or that's a couple of different reasons for having a trust. Another one might be to take advantage of some of the estate tax laws. In Massachusetts, if you pass away with over $1 million worth of assets, so that would be a combined real estate, savings, brokerage accounts, or life insurance, IRAs, then there could be an estate tax involved. There's a way with a married couple so that you could shelter at least $2 million worth of family assets by having typically an estate plan that utilizes trusts. That way you can benefit the surviving spouse to a degree of not having assets included in the surviving spouse's estate at the surviving spouse's death, and therefore minimizing and or eliminating Massachusetts and or federal estate taxes. So that would be another reason for having a trust. Now there's two types of trusts. One, the one that we've kind of been talking about, is the revocable living trust. There's also what they call a testamentary trust. That's a trust that comes under the will. So you can't put anything in it during lifetime, and it only comes into play after death. So again, there's various circumstances and reasons why you may want to go in that direction. We really don't have time, during this show to talk about it, but that is a distinction. A testamentary trust, or a trust that only comes into play with a will. So two things have to happen. Number one, you have to die, and then number two, the will has to be approved through the probate process. So that would be a will under a trust, as opposed to a living trust, and that's a trust that's established now during lifetime that you can fund and have assets in it during lifetime, again, if that's what you want to have happen. So a lot of this type of estate planning revolves around some counseling. It really depends on what's going on, what's important. Do we fund it now? Usually we do, but sometimes we don't. Sometimes it's just, hey, I want this to happen. I'm more concerned with, say, my kids or my beneficiaries after I'm gone, but you may not want to fund it now during your lifetime, and that's fine. That's where, with the combination of beneficiary designations and or the pour-over provision in your will, you can get that trust funded when you pass away, if that's what's important to you. So that would be a living trust versus a testamentary trust. There's various types of living trusts too. We have the revocable living trust. That's a trust that the one that I have set up, I have full control and power over. I can put assets in, money in, I can take it out whenever I want. I'm the trustee. During my lifetime, I'm the beneficiary. The only time my kids come into play would be after I'm gone and after my wife is gone. So that's a revocable living trust that I can amend and change and have full control over the income and the principal assets. They also have what we call irrevocable trusts.
Good segue when you mention access to principal versus income, or having access to both with a revocable trust, and leading into irrevocable. We have some time left, and I think you, knowing you'll be able to succinctly tell us about the irrevocable trusts and what you can and cannot access.
A little bit about it. Yeah, the irrevocable trust is usually used for estate tax purposes. Now, if you set up an irrevocable trust and you're not the trustee, if you're not the beneficiary, and if you don't have powers retained by yourself, then assets that you put into that trust are not going to be included in your estate when you pass away. So a lot of times we'll use that type of a vehicle for a life insurance policy. We may have what we call a second to die life insurance policy on a husband and wife, and maybe the thought is hey, we need some liquidity at the death of the second spouse, especially if there's a small business involved, or if we just wanted to have extra monies around to benefit children or other beneficiaries, then that's a good way of doing it, and in such a way that you're not adding to the estate tax burden of the estate. So that's what we call an irrevocable trust. You have to give up control of the principal. You can't amend it. You can't be the trustee typically, and you can't have access to income from that. So again, not appropriate for everybody. Depends on facts and circumstances, but those are utilized all the time as valid and appropriate estate planning documents. Now, having said that,
anticipated my question.
Another type of trust would be an asset protection trust. Now, with an asset protection trust, you need to give up control of something, and usually that would be principal. You can be the trustee. You can get access to and have income rights to the income that's generated by the trust. So if it's rental property and there was net rental income each month, that can all be paid out to you. Or if it was a portfolio that was generating interest and dividends that you needed to supplement your retirement or just your living purposes, then all of that income can be paid out to you. But the asset protection trust is going to protect the principal. If you put principal in there, you have to give up access to the principal. So again, we should do a whole show on asset protection trust, which we will do at some point in the future, because those are a lot more appropriate now than the irrevocable trust, which we used to use all the time when the federal estate tax laws were a lot different than they are now.
I was going to ask if you thought that we should devote a whole show, maybe the next time we visit here, to asset protection trusts. If you'd like to do that, I'm game.
Sure, well, we should do that. Now, in addition to that, we always forget to mention, but we run workshops twice a month that, again, are educational. There's no commitment, there's no cost, but it's part of our educational process with our clients, our potential clients, or any people who are just interested, where we spend 2 hours going through wills, trust, asset protection, qualifying for Medicaid, a little bit about estate taxes, and how assets should be held. So if people are interested, please look up our numbers at the end of the show and give our offices a call. And I think that's a great way to get educated, know what's out there, so that when it comes time for you to do your estate plan, you at least have a little bit of knowledge and maybe some feelings as to, oh, okay, this sounds interesting to me. I want to go in this direction.
Perfect. Great conclusion to another great show. My name is John Kennan, and my colleague and co-host Paul Tierney and I will see you again and soon. Take care.
Thank you.